Hello, I'm Dan Marr from the law firm of Hamblett Kerrigan here in Nashua, New Hampshire. I've been practicing law for 36 years in New Hampshire and 28 years in Massachusetts. And in both the state of New Hampshire and the Commonwealth of Massachusetts, I've litigated for either side these claims of gift manipulation. Basically, where somebody is saying, you got, usually from an older person, you got a gift during their lifetime or an inheritance after their death that was unfair. Maybe it might be children thinking that inheritance should have been split equally. Maybe it's a child upset that a live-in caregiver that is not part of the family, is not blood, is getting the assets, and there's bad feelings there, and there's claims. The two types of claims that are out there are generally mental competency or undue influence. Mental competency is basically saying the person didn't know what they're doing, they couldn't possibly deal with this. That gets tougher to argue when there's an attorney involved, but sometimes the medical records do bear out that the person didn't have the capacity to enter into any type of contract, including any type of gift or inheritance. The more likely one that's brought, more frequently one that's brought, is something called undue influence, where somebody is saying you usurped their free will by manipulating them such. The mere fact that you influenced them isn't enough. It's merely that they didn't have their own decision making because you kind of took it away from them, either because you threatened them or you said that the only reason you're not in a nursing home, if you don't want to be in a nursing home, is because I'm here, so you better leave me something. Or they just felt so they had to make sure they placated you because you're the one taking them to the doctors, you're taking them to groceries, they need you, and you're saying to them, I need you to remember me in your will or your trust or gift me assets through maybe making joint bank accounts where you put them in their names. In all those situations, the claim is unduly influencing. So in those cases, there are often medical records that deal with these issues, but if I'm defending one of these cases, or if I'm on the other side, I really want to get into the facts of other people interacting with these two people. Particularly the person that gave the gift, the donor. I want to find out if they're in a 55 and over community, what the neighbors think. If they're in a assisted living facility, they could be at different levels of assistance, and if they're not in the memory care unit where they're not capable of making decisions, there are people that are interacting with them at dinner or socializing them, maybe playing cards or whatever else. And I want to find out what they've been saying about their children, about anybody else that's involved. Now, in the caregiver situation, they would be living at home, and it would be the neighbors that would be talking. Maybe if it's a apartment, there might be walls that you're going to hear. Are they screaming at each other? Are they having good conversations? Do they like being around each other? Maybe I had one case that I tried the case, and the other side was saying, well, look, his spending habits changed substantially after he moved in with this caregiver, and they were going out to eat all the time. And the neighbors would say she could burn water. She was a horrible cook, and they went out because she was just a horrible cook. A fun part of a 5-day trial. It was pretty serious, but those facts matter. And she had a dog, so they would go out walking with the dog around the neighborhood, and there'd be people interacting with them in the nicer weather, where they'd be chatting. They go up to people's decks and they'd have chats with everybody, and you get to feel what they thought about what he thought about his children, and any estrangement that he had. So all those things matter. Really, those details matter if you can deal with that stuff, and you can see whether or not the caregiver that's getting the assets or the child who's getting the assets, are they trying to isolate this person from other people, or are they encouraging them to socialize with other people? All of that matters a great deal. I delve into those things regularly. I don't just rely on medical records. You can have medical hired experts that will say, I had one that was well known for saying regularly, I'm not going to say his name, but he'd say, as a psychiatrist, he'd say, I think it's a close call on mental competency, but there's certainly undue influence. And he's looking at medical records, never had talked to the person, and it was very easy to cross-examine that person when I had the facts of the real people talking to these people when he was alive and interacting with people. So facts matter. Judges care about that a great deal. Of course, they want to find out what really happened, not just some talking head of a medical record. Medical records do matter. and they're important, and the experts matter on that, but the real facts of what's going on in these people's lives are critical, and that's what's going to influence a judge if they're dealing with this case, or if there's a jury somehow involved, then a jury dealing with the case. But that's what I deal with. I've been on both sides of these cases, both in New Hampshire and Massachusetts. I'm happy to help. If the situation happens, I can talk to you about it. My telephone number is 603-883-5501, or you can check out our website at nationallaw.com. It's got a lot of these vlogs on there, a lot of useful information. Look forward to the opportunity of working with you if the opportunity arises. Thank you.